37 on the calendar, People v. Marcellus Johnson.
Good afternoon, Your Honor. Stanley Newsteader for appellant. 3 minutes will suffice for rebuttal. Let me get right to the point here. We're asking for a bright-line rule of law. Non-privileged phone conversations of pretrial detainees after right to counsel has attached are inadmissible unless the detainee has been explicitly warned not only that such conversations may be recorded and monitored by Department of Corrections, but that they may also be disclosed to prosecutors for use against them in court at the trial of the charges pending against them.
When and how did Mr. Johnson present that argument about the notice being insufficient regarding the consent? Below. When did he do that? When and how, yes.
On page, I'll get you the page on that. Expressly argued in the motion papers at our appendix at page 22. The people understood what we were arguing because they answered that at page 36 in their papers, appendix page 36. The trial court's ruling was kind of sketchy. It didn't really say much except interesting motion, counsel, but I'm denying it. But that was argued at the appellate division. They didn't have a problem with preservation. It's not a problem here. We argued it expressly at trial, and the key point is you gave notice to the prosecution. They answered it in those terms, and the judge saw their papers presumably as well as they saw ours. So
the 822 in their response establishes that you made the argument about the scope of consent. This particular argument that notification that the docs is listening, recording, preserving this.
They just said that the warnings produced a valid consent. The warnings alone were an adequate predicate for the consent. So they answered the very question in front of this court.
So if we put your bright line rule in place, so they put up a sign that says these can be used against you in court, that's good. That takes care of all the arguments in your brief.
Well, it takes care of one argument in the brief. We're looking for a bigger play here.
Not just looking for the bright line rule.
I'll take that bright line rule.
And then so the next case that comes up where there's a sign, there's no Sixth Amendment problem.
No Sixth Amendment problem. There's much less of a Sixth Amendment problem.
Why?
Because the defendant is on notice that he is giving up
So he can waive that Sixth Amendment claim without his lawyer being present.
Well, it's doubtful that he can do that, but at least the State would have the argument that he was told that he no longer would have the protection. He's giving up the protection of counsel, the medium of counsel, to intercede with him in the State. In other words, his connection to the prosecutor is done only through counsel and not alone.
How have the people elicited any statements from the defendant?
Basically, they haven't elicited it through Q&A. They didn't put some informer there to stimulate a conversation. I'm not saying that's not my argument.
Making a telephone available, is that enough to say that they're
No, it's essentially, I want to pick up on a phrase that Judge Fahey used in the prior case. It's essentially the warnings provided a false inducement, in a sense, a lulling inducement. They tell him that your conversations may be recorded and monitored. He's thinking Department of Corrections. He's not thinking cops and law enforcement. And the most damaging possibility that could emerge from speaking candidly on the phone to friends and family is the very thing omitted from the warnings.
Well, if someone were standing right next to him, another inmate, while he was on the phone overhearing these things, then that inmate could be called to say, not because somebody put that inmate there, but because the inmate just happened to be there.
That's true, but that's not State action. We're complaining about the State producing circumstances that make these conversations routinely available. And, the Department of Corrections and the DAs, the agency isn't enough to describe that relationship. That's an inadequate phrase. It's a tag team. The Department of Corrections records. They do almost no monitoring unless they get a specific tip of contraband coming in or gang activity or a threat to staff or corruption of staff. They don't do the monitoring. It's very restricted. It's a whole bureaucratic steps that have to be fulfilled in order to do any monitoring by a very limited specialized staff. So what they do is they pass off the monitoring to the DAs.
You make the point, I think, in your brief that regardless of any suspicions or thoughts that every single phone call at Rikers is taped. Is that right?
That's correct. Automatically, digitally recorded. And in due time, we haven't reached that as far as I know, the DAs won't even have to bother with transcribing these things. There'll be voice recognition technology to automatically decode all of this.
But you would agree the prison has legitimate security interest in
Absolutely do. I absolutely do.
So I don't know how many inmates are in Rikers right now.
I think roughly 10,000, I think, 9,000, 10,000.
I don't know how many calls are made, but you think the answer to that security concern is live monitoring of inmate calls on a with a reasonable suspicion that they're doing something wrong?
Well, I prefer that, but I don't care whether corrections monitors. I just care that they disclose to the police. That they shouldn't be doing.
Yeah, I thought in part your argument, or part of what you had argued was that they sometimes don't monitor because of the volume, but they're
That's right.
constantly
That's
recording,
right.
and that, in fact, there's this almost symbiotic relationship with the DA
That's
because
exactly right.
I can't monitor, you want it, you look at it, if you find something, let me know.
Right, but in answer to Judge Garcia's question, they should be monitoring for security purposes. They used to monitor for security purposes. It was difficult because it was reel to reel. Now that it's easier,
Well,
they
if
do less of it.
If they're monitoring legitimately,
Yes?
are you suggesting to us, and flesh this out a little for me, that the prosecutor doesn't have the ability to subpoena those records or get those records by court order?
I have no problem with them making a motion, like for a warrant. I don't have a problem with that. They issued an agency subpoena, which is not really approved by a judge. The judge signs off on it. They don't even have to show any specific reason to believe there be anything incriminating or of evidentiary value in those conversations. The case comes up and it's shortly before trial. They think the case is going to go to trial. They call corrections. They get these tapes and have them transcribed.
Here the judge actually reviewed the transcripts. Does that make any difference here and
No.
kept some of the information?
No,
out?
because we weren't a party to this subpoena. We learned it after the judge approves it when they come into court. We don't know that the subpoena.
What about the fact that there was one of the arguments that you make is that it would interfere with the ability to create a defense, but there was nothing in these tapes that we know of.
No, not in these tapes. That is true, but because it was redacted to the point where only the most incriminating things. You should hear these tapes. They're awful. They're not only incriminating in substance, they're ugly in tone and demeanor. It's the kind of thing that really would turn off a jury. I'm sorry. I lost my train of thought.
That the judge reviewed the tapes and
it doesn't matter whether the judge reviewed them. We're not part of that review. We didn't get notice of these subpoenas. I think
Let me interrupt you for a minute.
Yes.
I didn't see a subpoena in the record. I think these
physical
are just,
subpoena, no, but I think
I don't think so. I think they're just requests. In fact, if I understand Ms. Axelrod's brief, you just write a letter, or you just ask for them, and then they get them to you in 3 days.
Well, I know the rule, their own internal regulation says they have to get them back in 3 days, or rule on the request in 3 days. I'm not sure it makes a difference whether it's subpoena or not.
I thought, when we did the CLA, A, I thought it ought to be a subpoena, B, I thought it should be a judicial one because it's a public body or officer, and apparently it's neither. But Ms. Axelrod will straighten.
But we don't get it. We have no voice in that, and there's no real review of the need for that. They should be doing that through a request for a warrant. It's like a search warrant almost. But getting back to the agency thing, the agency is an inadequate phrase for this. They're a tag team. They work together, and the people rely on, Kuhlman and Cardona from this court. There has to be some sort of active stimulus. The active stimulus here, and they know it because they've been doing it for 6 years now, 7 years. They know how this thing works to produce valuable incriminating evidence. Those warnings, those incomplete warnings, lull the defendant into believing that the only people going to hear those conversations are the people they're speaking to, and if they're misbehaving in some way in terms of prison infractions, the Department of Corrections. There's no clue in there that police are involved, law enforcement is involved, outside of the institution.
The amicus brief from Legal Aid, I think, one of the two had some examples of problems that had cropped up in this in their view.
Right.
Did you want to?
Well, the thing with these conversations with friends and family, it's sort of a false dichotomy, really, when you think about it. It's an artificial dichotomy between privileged conversations and non-privileged conversations. Because when you're locked up, Any trial lawyer is dependent. When you're not locked up, your trial lawyer is accessible to you. He needs you to help develop the defense. You're locked up, the access is very limited. Anybody who knows Rikers Island, that's a day-long round trip. That's a Hajj to Mecca. It takes forever. And it's a whole work day. So the inmates are dependent on that phone to help their lawyers develop the defense. But try getting a trial lawyer, assigned counsel, which is what you're talking about in 80% of the cases. Try to get him by phone when you call. Just try. Leave a message, he can't call you back. You're locked up. Bottom line is you're dealing with friends and family to help develop your defense. That's part of your...
But that's not the issue in this particular case. In this particular case, it was incriminating statement.
That's right.
Wouldn't you think counsel, once right to counsel attached, if counsel is appointed or retained, says, don't admit anything on these telephones? Wouldn't they say that?
I think that is true, but one of the reasons, the right to counsel is to protect the defendant against being stupid. And he's isolated in that prison. Whatever the lawyer told him was who knows how many months before. And that's why I want to get back to that notice sign. Think of what the rule I'm requesting as essentially parallel to a fifth Miranda warning. The analog is a fifth Miranda warning that's sort of given once you're in jail. It's repeating the last of the Miranda warnings. An extra time when you're in jail on those notices, that anything you say is going to be recorded and monitored not just by the Department of Corrections, but by the very people who are prosecuting
So you want the rest of the line, and it may be used against you.
That's correct. And by the way, talking of the need for this kind of a warning, in the Miranda sphere, even an attorney who's in custody and being interrogated has to be given complete Miranda warnings. If you gave an attorney in custody a Miranda warning that excluded, that omitted, and it can be used against you at trial, that's suppressed. There's case law on that.
Counsel, given what you're arguing, the defendant at the trial court attempted to address this issue by a motion in limine?
Correct.
Why not a suppression motion?
I failed to see the distinction between them. The motion was made as a matter of law. This, for the reasons expressed in the motion papers and repeated here, it should not have come in. Those statements were admissible. This is just a label. I don't see what earthly difference it makes. The ruling would have been the same. The judge would have seen the same papers. What difference does it make? It's a pretrial thing. Call it whatever you like. I don't think it makes a difference.
Thank you, counsel.
Is my time up? I guess it is.
Sir.
Sorry.
Counsel.
Good afternoon, Your Honors. May it please the Court. My name is Susan Axelrod. I represent the respondent. Judge Piggott, I'll start right away by saying to you that, in fact, there was a subpoena issued. It was not reproduced in the record. It typically wouldn't be because that subpoena goes to Doc. Doc hangs on to it. But
Don't you keep a copy of your own subpoenas?
We do, but that would be kept internally in our file. It doesn't become part of the judicial record. But the prosecutor, I believe, actually represented, I can't remember if it was in motion practice or orally, but he did represent that he received these things pursuant to a subpoena.
But a subpoena is not required under the policy, is it?
No, it's not. Doc does not require it, but it does require a request. Well, Doc doesn't require it.
But should they?
I can't speak to.
Does your office do it as a matter of course? Use subpoenas as a matter of course, or do you not know?
Do we?
As a matter of course,
No,
do the ADAs use subpoenas as a
when we're getting these
Yes.
things, do we use subpoena?
Yes.
My understanding is that, yes, we are doing them pursuant to subpoena and not simply.
Counsel, do you seek the calls of every defendant who goes to trial?
I can't answer that with 100% certainty. I will certainly admit that we are aware that they are there, that it's on a checklist of things that it is suggested that you consider getting. And there's certainly no secret anywhere that we get them a lot, and we use these in a lot of cases.
And is there some standard threshold of determination that's made with respect to when you would seek out these whole-scale conversations?
There is not. And there doesn't have to be, because as things are set up, given that the defendant is given warnings, which I would like to address as well, the scope of those warnings, we are out. I'm sorry.
No, please, I'm interrupting you.
Okay. We're outside of the Fourth Amendment, which everybody concedes, And we are now in a consent situation, which means we're outside of the wiretap statute, which means we are not required to have any standard of proof. There's no statutory requirement that we show some threshold.
That's like the licensing agreements you sign when you go online and you want an app or something. You have to agree.
No, actually, it's
because
it's much
nobody
different.
reads them.
No, actually, Judge.
And I know you're going to show us, that warning, but there was a test. It's online, by the way, but with 12 pennies, and it says pick out the correct penny. And I guarantee you can't do it, because we think we know what a penny looks like, and then you look at all these other pennies, and you don't, because it just goes by you. You don't think of it.
And that would be an apt analogy if the defendant walked into prison, was handed a handbook, and then said, "Go with God." But not only is he handed a handbook that specifically explains to him how the monitoring process works, so that he can put his attorney's information in the file, so that won't be recorded. But there's that big sign right up there by the phone, and before each and every phone call that he makes, an electronic voice comes on and says, this call is subject to monitoring and recording.
But what's cute is you say that it's the Fourth and the Sixth Amendments don't count. We have got this thing so cooked that this guy, who the lawyer said, you've got to get a hold of your parents and tell them to get these two witnesses here, that can be listened to by the DA and action can be taken on it.
No.
And yes, the
lawyer said no. We don't hear that call.
Oh yeah, you're hearing the call from the defendant, who then calls his parents and says, my lawyer says we got to get Johnny and Frankie in because they're supposed to help us with this case. Or as I think Brooklyn pointed out, where somebody pointed to a defendant, told the defendant's wife that the defendant was calling his paramour to try to get the wife to not testify on behalf of the defendant. Now, I don't know if that's true or not. That's just it's one of the things they put in. But can you see the possibilities of abuse?
I can see the possibilities that defendants end up in positions where they're not supposed to be. But the idea, and there's certainly no record here, and even in the affirmations that legal aid supplied, the idea that an experienced attorney would call a defendant, have a defendant in jail, and say to him, listen, use the phone to do these things, I would submit doesn't exist. And if it does, that can be dealt with at the appropriate time.
Probably ineffective assistance of counsel.
Exactly. There are other ramifications.
What's the danger of the rule that you just add a few words, and this may be used against you?
We would have no problem with that, but DOC came up with this. We didn't come up with this. This is DOC's policy.
But you're the one that uses them. They even say that. They say that, we don't, all we do is record them. We don't even monitor anymore. It's all the DA, and somebody makes the allegation that you use student interns to sit there and listen to these things. It almost sounds 1984.
Okay, first of all, the idea that DOC is saying, no, we don't monitor, we leave the DA, that statement exists nowhere other than from defense counsel's mouth. He hasn't shown that that's what they say. DOC set up a policy for internal security, and they came up with certain rules for when they would monitor that would encourage their safety and limit abusive practices by correctional agents. The district attorney's office then subpoenas those conversations because they think there is going to be evidence. That's what we do. We look for evidence. There has never been.
If they turn you down, what do you do?
We're out of luck.
For some reason they turn you down. I know that they argue that they never turn you down, but let's assume you have a situation where they turn you down. What would you do?
I believe that we are out of luck. And we may be able, if we are doing it by...
You wouldn't go to court?
Well,
we need access to these?
Then it depends on a number of things. If we've issued a subpoena and they've denied the subpoena and they do a motion to quash, that puts us in court. If, however, a prosecutor were doing this just by letter, well, then we're out of luck because it is within their ability to deny us. So we are not a symbiotic, we're not yin and yang
But
here.
you ask for them even if you have no idea what's been said, correct?
That's correct, because we listen.
You're looking for something.
We listen to find out if there's evidence that's been created that we can use at trial. And in terms of the allegations about interns.
So what would be your argument on the motion to quash?
That
you don't know what's been said.
That we're entitled to these records pursuant to the county law that requires the Department of Correction to turn things over to us, and that they're actually in violation of county law. But in terms of the intern, again, there's no record of it. Here, the prosecutor himself listened to these phone calls and made the decision as to what to do. So all of these
was
things are outside of the record and simply weren't.
Can I go back to this thing about the county law? So you're saying that the docs has no discretion to deny you?
According to the county law, it appears that they don't. And so it looks like the reasons that they have their policies in place. And again, we're not DOC, and DOC lawyers didn't come and talk to us. So I'm speculating myself a little bit. But it looks like the reason they have these policies in place is so that they can comport with the county law in a way that makes sense for them,
It gets to the point, not in this case, but in another one where the judge, it was irrelevant to the particular case when I was reading the transcript, said, by the way, have you subpoenaed Rikers yet? I mean, it was almost as if, one of the things that I'm expecting to happen in this case is that you guys are going to subpoena Rikers. And I thought, geez, it's just SOP.
It is, and it's also well known and well documented. And for that reason, somebody on the bench just brought up that the defendant is given an attorney in arraignments. He's given somebody who can say to him, listen, don't talk about the case.
But you're
on the
officers of the
phone.
court. And I realize you're looking for evidence, but boy, as your opponent points out, when you listen to these tapes and you realize I would convict this guy without any evidence based upon what was said on those tapes. He sounds mean. He sounds nasty. He swears. He makes all kinds of and all of this got before a jury.
No, portions of 9 phone calls got before a jury.
Yeah, the ones that we got, I think. I mean,
yes, that's what I sent to you.
Yeah.
But if, there's a judge sitting there reviewing all of this evidence and making determinations on whether something is more prejudiced than probative. And if we're just trying to introduce tapes to show, well, gee, he's a bad guy.
Yeah, but the judge has been reversed before. I know it for a fact.
Judge, if you're saying to me this is a problem, and my answer to you is, but a judge can always take steps to prevent that problem by saying this is more probative, this is not more probative, it's too prejudicial.
Mm-hmm.
And the comeback is, but judges get it wrong. I don't know where to go with that, but the truth.
Well, I'm talking about it in the context of this case. I don't know if it was preserved or not, but one of the points that I thought was being made was that if you listen to these tapes, they're pretty scurrilous.
Well, first of all, I don't believe that was one of the bases for the objections. There was some Molyneux evidence that had to be kept out, and I believe that was the basis for the discussion about what was going to be exercised. And also, not everything was relevant. But the bottom line is, the fact that we get these tapes and the fact that we find information on them that is useful to us doesn't mean that defendants aren't without remedies if they think there are some harms, if they think we're trying to be too expansive. Here we were trying to get Molyneux evidence in. There's a judge sitting there who can make rulings as to evidentiary rulings.
How does a defendant remedy a problem if the people are hearing their trial strategy? What witnesses they're going to call?
I think, first of all, our prosecutors weren't born yesterday, and a lot of these strategies aren't surprises. So it's not like a defendant who's exhibited odd behavior. We're not anticipating an EED defense, and that we need to hear that.
Well, what about an alibi defense? I mean, how would you know what their alibi was going to be unless somebody overheard their conversation?
Because we're going to get notice of that anyway. So a lot of the defendants' complaints about all of this, I submit when you sort of parse them out, they're not harmed to the degree that they're claiming. Now, obviously, there's information that gets to us that defense attorneys.
But counsel, obviously, if they were discussing with the attorneys, you couldn't hear it. So
Right.
Your answer to that, well, eventually would know is not a response, because their point is, and I understand your position, lawyers can let them know they've got notice, and you're working in a world of rationalities. They're suggesting that people are desperate and don't act necessarily so rational, and they're not with lawyers all the time, and lawyers are hard to reach. But let me ask you this question. Let me actually get to a question. What's your position on this question of the notice and the scope of the consent with respect to preservation?
Well, they never preserved that. They simply didn't argue that below. They also didn't argue it in the appellate division. And because they didn't ask for a suppression motion, no testimony was taken. So there's a lot of supposition that a
They said you
defendant.
responded to it. What was the nature of your response?
We said consent, but first of all, the obligation isn't on us to preserve. It's on them to preserve and make records, which they didn't. And secondly, I believe that what happened actually was that both parties filed their papers pretty much around the same time, and so we were anticipating that they would be arguing consent, which was why we raised it. But they didn't raise it. The judge didn't decide on it. They didn't raise it in the appellate division. The judge didn't decide on it. Had they done a suppression, move for suppression, that would have been a taking of testimony, as opposed to what they did, which was a motion in limine, would place this within the court's discretion. Defense counsel has been making leaps that a defendant who reads these notices, which say these phone calls will be recorded and monitored pursuant to DOC policy, must assume that it's a very limited reason. But then, ironically, he turns around and says, but Doc and the DA's office are they're basically one beast. So apparently the defendant doesn't know that, except that we're acting that way. So there is no evidence here as to whether the defendant knew or even cared as to where these conversations were going to be going.
One of the things, I don't know what the answer to this is, maybe you can enlighten me, but one of the things that comes up is that the fact that if you can't make bail, this is your purgatory. You're now going to have all your phones monitored. And if Docs doesn't monitor it, simply records. And then if the only purpose they're put to later is for you, he used the term trawl, to fish. Why do we do this?
You like search.
Why do we do? Well, search is required probable cause, I suppose. But why do this at all? I mean, it's true, is it not, that it's people who can't make bail who are not able to make phone calls to witnesses or things like that and help their lawyer, but the people who can't make bail, are stuck.
Well, first of all, that's a policy argument,
Right.
and he can't point to a statute or a constitutional provision. And this Court has routinely said that this Court grants relief based on constitutional violations and statutory violations. So I don't want to make light of his argument, but it's not a legal argument for the purpose of this Court to grant a remedy. I also just want to point out that while he's talking about the unfairness of in-defendants, out-defendants also need to keep their mouths shut or they are creating evidence. And while it may not necessarily be recorded phone calls, although they could call somebody who has an axe to grind with them who would record that phone call and turn it over to the people, the bottom line is when you are a defendant, you are given a lawyer who explains to you the ramifications that every time you open your mouth, you are creating evidence. And the best way not to create evidence is not to open your mouth about the case. And while somebody talked about stupid people or stupid defendants or whatever the language was, this Court has specifically said that the Sixth Amendment does not give defendants immunity from statements they've made every time their lawyer isn't there. The best that we can do, and the only thing that is required, is that we give the defendant the tools so that when he makes decisions, he is armed with the tools to make them. If he makes stupid decisions, that's on him. But he finds no relief in the Constitution because he is not acting in his best interest. And in this particular case, the defendant was warned in sort of broad strokes that his phone calls were being recorded and monitored. And by the way, the warnings didn't say, well, while we say recorded and monitored, not so much with the monitoring. We might do it, we might not do it. It said recorded and monitored, which meant when he picked up that phone, he had every expectation that somebody else was listening to that call. When he had that expectation, he consented to the recording of those conversations, and he lost the right to control how those conversations were used. And I see that my time is up. I will rely for the remainder of my arguments on my brief. Thank you.
Thank you. Counsel?
Counsel, before you start, could we pick up with remedy? So assume this is a Fourth Amendment violation. Assume for now it's not a Sixth Amendment violation along the lines of Judge Stein's question of state action. What's the remedy?
Remedy is inadmissibility of the evidence.
Everything's inadmissible.
Yes, everything harvested by this big trolling net without any judicial review, without anything resembling a reason to believe that anything incriminating would be found there. It's just a wholesale harvesting of intimate conversations.
And that remedy is based on what?
On the right to counsel.
But that's a Sixth Amendment violation.
Correct. We're not arguing Fourth Amendment.
Let's assume there's no Sixth Amendment.
No Fourth Amendment. We're not making a Fourth Amendment.
Okay, but let's assume for now there's no Sixth Amendment.
Then it's the problem with the consent. And
the problem with the consent leads to essentially suppression of all the tapes.
That's correct.
Not a review by the judge in an in limine motion to say, going to Judge Pickett's point, this is too prejudicial, the tone, put a transcript in.
No, that's a
supervisory
separate
point. You listen to defense strategy. I find that misconduct on the part of the people, and taking action like that. It's a wholesale suppression of evidence.
That's correct. Now, whether it's prejudicial, the prejudice probative value thing, that's a freestanding independent grievance. So that if they came in, you might have an argument on that ground. But we're looking for wholesale suppression of these
But
recordings.
this isn't evidence, right?
Of course, but we suppress evidence all the time.
Based on a constitutional violation.
We have it here.
Right, but assume it's not.
Okay, just a moment. Let me get to that. There are 4 cases involving violations of non-constitutional norms, okay? I cite them in the brief. People have it in their brief. And they were, one was something the postmaster did that he shouldn't have done that got information, and that was suppressed. It was in violation of postal regulations. Suppressed. There was another one with release of a sealed photograph that was used to affect an ID. A reliable ID, but an ID. Not suppressed. But there was another case where the violation was of the search warrant statute. The judge to whom the warrant was turned didn't do the right paperwork. In that case, this court suppressed that. Why? Because it was closely intertwined with the vindication of a constitutional right. They are a Fourth Amendment right. Here we're talking about...
That's my question, counsel.
Yes.
You said you're not arguing the Fourth Amendment.
We are not.
And I wondered whether, because in your brief you used language suggesting you were arguing Fifth Amendment, right against self-incrimination, but are you arguing that too?
Well, the Sixth Amendment is there to prevent self-incrimination. That's one of the purposes of having a lawyer.
Well, but my point is that if you're not arguing Fourth or Fifth Amendment, and if you set aside Sixth Amendment, what would the suppression be based on? And the only thing you've mentioned so far is the postal regulation violation.
No. First of all...
A regulation violation, that's what you're saying.
I am, but I'm also saying that the consent that they're relying on is inadequate because the warnings that preceded it were limited. They're not as expansive as the consent that the people want to extract from it. It's like...
I guess the problem I have with that is that the basis of the warning is a constitutional violation. It's Miranda-esque.
Yes.
That's the problem I have. So if there's no constitutional violation, then we're back on the regs, and you've got a tougher argument.
Well, I do, but I don't think I'm off the Constitution. Let me make an appeal to tradition in this Court. Before any lawyer in this room was admitted to the bar, New York State Court of Appeals was the cutting edge of right to counsel law, going back to the early 60s. And by increment over time, this Court has been more and more said, always increasing, bumping up the ever so slightly the right to counsel, more expansive, greater awareness of the importance of counsel's role in protecting a defense interests. Don't be shy here. This is a cutting-edge opportunity. This really does touch upon right to counsel. And my last thought is this. 2 last thoughts. First, we're using analog law for a digital age. This is too easy, all this tape recording. Even NSA it just does metadata, and that's been stopped. They don't have the actual conversations. This Court has recognized how modern technology is so intrusive that we've made adjustments in the law. The GPS case, Weaver some years ago. And the Supreme Court just recently, Riley, with search of a cell phone upon arrest, as incident to an arrest. So there's an awareness all over, including in this Court, that technology has changed the formulas here. And we can't rely on the neat little stiff categories of an analog age.
Thank you, sir.
Thank you.